pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, we'll move to approval of the agenda. There's 3 sets of minutes. There are draft minutes, approval, and then call the public, new business, and old business, both with one item. Entertain a motion for approval of the agenda.
So moved.
Support? Any opposed? All righty. So the August 8th minutes. What was that?
Move we approve the August 8th minutes.
Issues on there. There's a motion to approve August 8th minutes.
Got my email?
Presented. Any opposed? Any support?
Support.
Okay, Garrett supported. All in favor, please say aye.
Aye.
Aye. Go to September 12th minutes. And only item here, Ross, on this item is a typo.
Okay, that's mine.
But
And that is,
item number 2 on September minutes.
page 3.
Page 2.
Page 2 or 3.
Page 2. You're right. Got it. Okay. Any other items, guys? Entertain a motion for approval. September 12th minutes as amended.
As amended.
Yep.
Support.
Okay. All in favor, please say aye.
Aye.
Opposed? Move to the October 10th minutes. I did not have any items there. You got anything, guys?
I move to approve.
Any motion to approve October 10th minutes as submitted and supported. All in favor, please say aye.
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 Who supported it?
Garrett.
Thank you.
So we'll move into call for the public next, and just before we get into a lot of the, I understand that from our last meeting, there was a lot of public comment regarding the utility scale solar facilities, and anticipating that there will be some more tonight, which is good. We want to hear from people, and but given the recent developments of the state government, there will be a lot of updates that will need to take place, or changes in how we approach it, which Mateo will give a summary of what we're gonna look at to consider. So we'll discuss that as part of old business item number 1. That's the plan. So we'll move into call to the public at this time. Public comment, go ahead.
Kim Farkalosi, Deer Park Court. I wanted to add, I think that we should continue going along doing it the way we want to do it, regardless of what the state says.
Yes.
Because I believe that there will be the opportunity always to fight what the state is doing, and that there will be fights, so we need to proceed as if we do have control first. Secondly, when we talk about screening, you need to add C on the screening, because you don't have C, you just blocked out B. It's a little edit. But I would like to add screening along the highway. Part of the reason that our town looks so awesome is when we drive through, it's very rural. If you have those solar things, you know, if you screen, we got the screening on 3 sides, you can add it to 4 sides, particularly wherever there are natural trees or current trees existing, you know, the old oaks that we have. Now, I think the overlay covers a part that is pretty much flat because it's used in farming, but there's still some tree line on the front. So I think we should screen all the way around this. It's not going to hurt the functioning of the facility. They still will get the sun. So I would like to add that. And when we decommission under item H, I would like to add that they must include a soil test after to make sure they didn't like pollute all of our land there. And if they did, put something in that they have to remediate it, or, you know, I don't know how we do that, but something on that. And then I didn't catch where we excluded the battery storage. I know we talked about that, and maybe I missed it when I was going through it.
It's crossed out.
Yeah, it looked like it was crossed out, so I would like to recommend we add that back. That's all I got.
Thanks. Great. Any others?
I'm Jeanette, I live in Tyrone Township, and I am representing almost 300 people in a private Facebook group, or in a public group, and also an extensive subscription list to Tyrone Township Watch. What you guys just did here, I had sent an email to Rich. I told him there are mistakes and misrepresentations in the meeting minutes, and you just approved them anyway. So I would ask that you would rescind that approval, allow me to send you what those mistakes and errors are. I went through the 3 meetings, listening to the videos. There are misquotes, and it's not right that you approve them, especially when I alerted you to it. So hopefully that you'll do that. I had 2 lines of comments here. What to say if Rich has not changed the agenda, and what to say if Rich has changed the agenda. So he did not change it. And you'll see that on the second page of the handout that I showed you guys, or maybe it's on the first, but basically some items that I asked Rich to add. Today, Rich got back to me and told me that I needed to fill out an application to have something go on the agenda. And the supervisor answered us back and said that's not true. All that he has to do is ask Rich, and Rich has the authority to put it on the agenda. He has chosen not to put those items on the agenda. Right?
Some of it's partially true, but it's not all the way true.
Well, and it's.
But we can keep going. Address things
Okay.
throughout our meeting.
All right, so you all have before you a packet. It includes a request that I made to Rich asking if you would put it on the agenda. Let me see, I went through that already. So you saw the email from the supervisor, but you still chose not to put it on there. So obviously you deem those items not necessary. So the audience knows what I'm talking about. Many of them do already. It's regarding the resolution that many townships, 82 to be exact, and 32 counties have put forth. And I want you to know that many of them have come on board this week, even as early as yesterday, because they've all looked at it, they've listened to their residents who have said, we want you to take a stand for us. We know it's a resolution, we know it's not a law, we want you to stand for us. And planning commissions have done this, aside from their board, and you can look at the list. They have been passed, and they have been resolved, and they have been submitted to the state. So I'm asking you guys to do that. As you know, that we had asked the supervisor to look at this, and he basically told us he was working behind the scenes. We don't know what working behind the scenes is, and that's why we're asking you, as a planning commission, to stand up for us, because our board is not. Our board is not listening to us. They just demeaned the whole idea of resolutions by saying that they're ceremonial and that his feelings and thoughts were more important than any resolution. That's his message that he sent out. I've got screenshots of it. I think I sent it to you guys, but that's his take on it. So if this is something that you don't want to do, and here, when you come to miscellaneous business tonight, every one of you guys have the right to say, excuse me, let's talk about what's before us. Let's discuss this. The people want us to discuss this. You all have a right to say something and to bring it up. And I want to ask, are you being told by somebody not to do what the people want you to do, to not entertain the subjects that they want to have talked about? You have a voice too. And I'll tell you, when I went to Lansing, I ran into planning commission people from other townships. I ran into supervisors, and they all said the same thing. Shame on Tyrone Township for the way that I'm not saying you, but our board, the way he's behaving and telling us that our voice doesn't matter. So I'm asking you guys, take a stand. Stand up. Do what's right. And show the people that, yes, I realize that you're appointed, except for Mr. Schultz, you're elected. But when it comes to an election, there's going to be a change, and it's going to trickle down to the appointees. And do you guys really want this to be your legacy, that you don't listen to the people? So I'm asking you respectfully to, when it's miscellaneous business time, one of you, pick that up and look at it and say, let's talk about it. Thank you.
Chuck Tidwell, 9005 Green Hickory. My wife and I lived in Tyrone Township for the last 14 years. Before that, for 42 years, we lived north of Lennon, just off of M13, about 4 or 5 miles north. At that time, that was a productive area of crop farms, and we had deer everywhere, other wildlife. Now it's a total eyesore. And I would encourage everybody here to take the time and drive up there north of Lennon and turn left about 4 or 5 miles north, and you can see what I mean. Pay a lot of attention to the people that have put their life savings into a small home, maybe on one of those roads, and now they have solar panels on 4 sides of them. Those homes are worthless. There's nobody going to ever buy that house. They look just terrible. They're just miles of solar farms up there. You know, you might think I'm against electric cars and electric homes. That's not true. That's not true. What I am against is a total lack of common sense that's been used in placing these solar panels everywhere. It makes no sense at all. It makes no economic sense without the subsidies of up to 30% that our government in Washington is paying. Besides, that's you is paying that. Without that, these things would never fly, any of them. And environmentally, it's really suspect whether solar panels are even environmentally friendly. By the time they're manufactured and so on, it's questionable. I have some questions for you. Do you know where the 5 largest solar manufacturers are in the world?
China.
They're all in China.
Mm-hmm.
Guess what? China is putting a new electric generating plant online every week, and sometimes 2 a week. They're funded with, they're actually made with brown coal.
Yep.
China's got a lot of coal, brown coal, but it's nasty. It's like burning a wet log in your fireplace. But do you think that pollution stops at the border?
Yeah.
No, it's coming over here and you guys are breathing it every day. So that is, environmentally, it's very questionable. Do you know what the life of a solar panel is? Or the converters? The converter changes the DC power into AC power that we can use. Well, the life varies from 15 to 30 years. If you go online, they're telling you it's going to last forever, because those are the people trying to sell you this stuff. They're not the ones that have the facts on it. And the inverters are only going to last sometimes shorter than that period of time, less than 15 years, and they're going to be replaced. You know, the recent government study says that in 2030, that's 6 years from now, there's going to be 1 million tons of solar panels that have to be replaced. 1 million in this country. 1 million tons. You know how they have to be recycled. Do you know how those are recycled? More than 90% of them go to the dump.
Yeah.
Because it costs $20 to recycle a panel, and it costs $2 to throw it in the dump. Now what goes in the dump are things like cadmium and lead and copper and all the other things that are used in them. And that stuff is leaching into our groundwater source. And you guys are going to have that. I do have a request for the board before the next meeting. If you haven't been up to see that disaster up there north of Linden, I'd invite you or suggest you make a trip up there just to see what it really looks like. And not only that, but I would suggest and ask that by the next board meeting, you have looked at and tried to follow the money on these solar projects. Go back and find out who in the township is going to benefit and make money off these solar projects. And then come back next month or when the next meeting is and tell us about who the people and the companies are that are going to make all the money on this. Because it's not these folks. Thank you.
Scott Dietrich, White Lake Road. Just to make it straight, I'm not for a field full of solar panels. But there's so much being said. It's just like this gentleman said, we are terrible. We don't recycle anything like we should. It isn't just the solar panels, it's everything. We got rivers and streams and oceans just full of plastic. And I don't know why we just can't get a program. But other than that, Mike was saying, I don't know how much work we're going to get done because meetings get canceled every time we turn around.
Exactly.
How does the government operate when you're out? I've never seen so many meetings canceled in my life. And we got a lot of important issues. We're not even working on the master plan tonight. He was going to hire a lawyer. Is that a done deal? They know something about this solar stuff?
Yeah, the lawyer.
It's on the agenda at the next board meeting.
Okay.
Oh, for crying out loud.
So we this something like this. There's not a hurry. We don't have anybody here
There
coming
is.
yet
Yeah,
to
they
put a
are.
solar panel. No, they're not here yet. We're just preparing for in case they do. Okay, we just prepare. This township, as far as I'm concerned, I don't see enough sun. I don't know how the hell they could make any money anyway. Because I live in Michigan, and the last 2 days we've got sun in a month. So, but anyways, we don't want to fight each other. We don't want to argue.
Hold on,
Let me finish. I'm not for it. I'm not for it. Don't get me wrong. But it just, everybody, I've heard a whole bunch of crap on here. I don't know the truth. I don't.
The truth is there.
No, because the gentleman was right.
Hold on, Scott, finish your public
Okay,
comment.
I am. The gentleman's right. It's this. Both sides. So we're stuck in the middle. So we need a lawyer or somebody. I still don't want to see a field full of this crap. I don't want to see because I just don't want the unsightliness. Because I want this township. I fight every day for this township. I've been down here. My family's been out here since the 50s, not 14 years. So I've seen a lot of changes. So, but I hear a lot of stuff, and it just gets tiring to hear the same old stuff over and over again. That there's always an adverse just something that's, you know, anything we do, there's always something bad that comes from it. So this is just another thing down the line we gotta deal with. And if we don't do something in the future, where are we going? I mean, I don't know. I don't know, but people, I mean, I know we're all upset. We want our township to look beautiful. We want it peaceful. But definitely, honestly, I don't want solar panels field. But I know there's other alternatives. But we need this. We need somebody, the lawyer. We need somebody that doesn't have politics, doesn't have a financial. We need somebody that knows, that can teach us, not just take our money, what the truth is, and what we're looking forward to. This gentleman here tries to do the best he can because he deals with it with other communities that are going through this. But I mean, we're all going to fight together. We don't want to fight with each other, but we ought to fight together to keep your township a beautiful place to live in. But I hear all the stuff and my head spins because it's the same old stuff. I mean, I've heard the stuff about battery electrics, and I've seen video of how they recycle them, and it pretty much is a lot recycled. If we do it, are we doing it? That's the problem. If we do it, can it be done right? And he's right. If they don't do it, I don't want it to go in the landfill. I want everything to be recycled. But and another thing is, this is my last statement. We're fighting, and Jeanette, you brought this up, we're fighting with the county and the state over this, them controlling us. And it goes back to the speed control on our roads. We can't control that. The state does that. The county tells us what to do. We're stuck. It's terrible because we're a township that people all come together. This is what we want for our township. But the county says, no, you got to do it this way. The state says, no, you got to do it this way. So we're stuck.
No, we don't lay
No,
down.
but I'm just saying that. But that's the way it's been. We want to fight that. But it just isn't on the solar panel issue. It's on everything. Why can't we run our communities without so much interference from the county and the state? They control too much. They got too much power. And if we're going to go fight for one thing, fight for the whole ball of wax. Say, listen, we're going to control our township. And this is crap. I'm sorry. They just railroad us. It's just like the facility across from my house. They just come here and told me, well, you're going to run a drug and alcohol treatment center right across my house, and I live on a lake. I mean, how many people want a drug and alcohol treatment center across from your house? You know?
Thanks, Scott.
But you know what? The state says, I gotta have it. They can have it there. But see, that's what I'm saying. It just ain't one issue.
Thank you, Scott. Any other public comment?
My comment to the panel is, the question is why? Why solar panels? At best, they convert solar energy into electrical energy at 20-25% efficiency. Now, if most people work 20-25% in their jobs, they should be terminated, in my opinion. So, why are we doing this?
Would you mind stating your name for the record?
Oh, Craig Drellis,
Thank you.
Hartland Road. I don't get it. At that kind of efficiency, what's the real game plan here? What's the real benefit
Subsidies.
besides money to certain people? What's the benefit to the community at that kind of efficiency? There isn't any. So that's my point.
Thank you.
And I'm opposed to it 100%.
Thanks. Gentleman over here.
I'm Keith Kramer, 9054 Green Hickory in Fenton, Tyrone Township. I have my comments on the first item. And what I have is a number of things. My first question is, why is it even here? There was approved plans, and somehow they got built to a different standard. So what are you going to do? Are you going to let them get away with it? Or are you going to not do anything and make them build it the right way? Because if you don't, why bother having a planning commission? Why bother having any zoning ordinances? Because somebody, all they have to do is put in something different than you allow them to do. Thank you.
Thank you. Any other public comment? Okay, moving to new business, item number 1 is DMN Properties Minor change to site plan. And I don't see the applicant in attendance, but I think for the planning commission, this is the original site plan here. I believe.
Do you want me to give a brief?
Yeah, go ahead, Ross.
So, we received the original application for 2 shared private driveways, which were part of a land division application. Land division applications typically don't need to go through the planning commission, but because there are shared private driveways, it is required for site plan review. We had what is shown up there, the original approved site plan. That was approved by the township. It was not built in accordance with the approved site plans. One of the 2 shared driveways, the turnaround was altered from the T turnaround, which the planning commission approved, to a Y type configuration. The justification from the applicant was that they went to Eagle and they were told that due to the proximity to the wetlands, they did need to locate a retention basin in that area that would be part of the shared driveway easement. They went ahead, they modified the plans, they built it without approval from the township. That's why we're at the situation here. They did not get approval. It is not an acceptable design in accordance with our ordinance unless it were approved as modified by the township. We have been trying to get a plan that would conform with the ordinance standards. As of this time, so far, what we've received is the latest plans, which are included in the packet. The plans included in the packet, while it is a cul-de-sac design, which is one of the 2 authorized designs for shared private driveways, providing access to more than 3 parcels, it does not quite meet the minimum turning radius as required by the ordinance. This particular shared driveway would be utilized by 2 private residences. The planning commission has the authority at this time to either accept the plans as are. If they were to do that, then it does require township board approval of the modified plans, or they can require revised plans that are designed in accordance with the ordinance. Right now, what is shown on the plans is a 48-degree turning radius. The minimum required for cul-de-sacs for a shared driveway turnaround with a center island is 55 feet. That said, we have received a review from the fire department having jurisdiction over the property, stating that yes, it may be feasible to navigate that with a fire truck, which would be the largest vehicle that would necessarily traverse that turnaround. In instances like that, the township board does have the authority to modify the design requirements, assuming that it meets sound planning standards and general public health and safety. In this case, what was described to me by the applicant is there are existing utilities. There is a transformer pad that would be located within the internal island. That, in combination with, as you can see, the basin down to the south, which is mandated through the state by Eagle, kind of dictated their modified design like this. Whether or not they can create a design that complies more closely to the ordinance is not specified, but given all the information that we have when we've been going throughout this process, this design is substantially more close to our permissible design standards. What was initially approved was a T turnaround design, which arguably is less navigable than this. One thing that I did not mention is within the fire review is that one recommendation due to the minimized turning radius and the surface area is that the applicant does erect no parking signs. That way it ensures that if there was a need for emergency access to the site, a fire truck would be able to navigate that turnaround. So at this point, the planning commission can make a number of decisions. They can either determine that Yes, we do believe that this can be approved as presented, based on the information that has been provided. If so, it would require modified standards, which would require a action by the Township Board. The other option would be to request that the applicant provide updated plans, which it's unknown whether or not that it's possible at this time based on all of the other variables in play. Do we have any representation for the applicant in attendance?
My husband and I are the owners of lot 4.
Okay.
So we bought this property, back in June of this year. It was disclosed that there was an issue with the road, but this has since then stopped us from being able to make any progress on building our home. And none of this was known to us. So this retention pond where it is located is the main issue, as you said. And this new plan is still cutting into our property a lot, but like you said, the fire truck said that he could come and turn around. And truly at this point, we just want the ability to be able to build our house. We understand that the road does need to be altered to meet the T or the cul-de-sac. And we waited X number of months for something that was essentially 100% out of our control. So we would just appreciate your consideration on the approval of the amended plans that are being presented.
So I would defer to the planning commission to discuss based on the information that's presented to us. We do have the original plan, we do have the modified plan. We do know that a cul-de-sac is a permissible design for a turnaround for a shared driveway, providing access to more than 3 parcels. The only potential issue with that is the slightly less than 55-foot turning radius. So that I would defer to the fire department, which we do have that review letter included in the packet. If you do have any questions, I know that John is here to answer any of them, but I would suggest at this time the planning commission just kind of reviews the information, sees where we should go from here. It can go a number of different ways, but it's been an ongoing issue. My personal opinion is the turnaround design is more navigable than what was initially approved, but I don't have 100% expertise in that area, so I would defer to.
Hey, Ross, when we saw this application the first
Can I
time,
make one statement? The fire truck's not the biggest vehicle that's got around here. I work for Consumers Energy, and those things are nightmare cells. For emergency situations, to access to our gas and our electric. We have, our trailers are 45 foot long, which is as long as a fire truck, not including our truck. That'd be my only concern.
I'm just going based on what the ordinance says, which is for emergency vehicles, not utility vehicles, which
We have
that
a
is.
fire down there, if there's gas or electric down there, we gotta get there and shut it off. We work with the fire department every day.
Address that's something.
That's just a statement, and again, you can, I just want to make that clear, that is not the biggest vehicle out there. It is going to be a consumer's energy vehicle, we gotta get down for gas or electric.
yeah, so Ross, when was there any reason the inside radius couldn't be smaller?
I was hoping that the applicant would be in attendance to be able to elaborate on that a little bit further. From what I've gathered, based on the information provided, is due to the location of a transformer pad.
Okay.
We have consumers right there, you can move it.
Is that a feasible option? I mean,
Move it.
transformer pad.
Yeah. Move it
No,
electric,
but the,
So if
for us
that's
as the
how the
planning
planning
commission,
commission,
thanks, we have to.
that's one of the
determine
options that the
that.
planning commission could.
Yeah.
It's 55-foot radius, no?
What is in the ordinance is the.
When there's a center island, it's a minimum of 40.
So, right.
That's if there is a center island, but if there's no center island, then it's different.
Right.
So if the transformer pad is able to be relocated, then that would be a different story.
Right,
This is the last parcel that's gonna be serviced by this driveway. That's it.
Nothing, yeah.
Two parcels.
Yeah.
But it is a turnaround for a shared driveway and, you know, it's just for sound planning practices. It's not my call to make.
That's why.
Right. It's 48 as shown with the center island, yes. What have they got?
Yeah, thanks, Ross. That's a good summary. And I know when we originally saw this application, it was a T turnaround, and we wanted a cul-de-sac, and I think this is a good resolution, whether or not the sizing is correct. We can talk about that.
It's at your discretion, and
Yeah.
as a modified standard, if it goes to the township board at that point, they could require additional information, or they could shoot it back to the planning commission if they deem necessary. I think the reality of it is, it was part of a land division. The land division occurred a very long time ago. There are people who purchase properties that are unfortunately unable to get land use permits because of this issue. And, you know, that very well may be 100% the fault of the developer, but it is a situation where we received, you know, a request for a revised site plan, and this is just the process that we need to go through.
For us, there's some action on it. I don't know if it's not here. We have questions for fire chief or not. This interview was pretty straightforward.
Yeah. You got the fire captain here, don't you?
Yeah.
I mean, the plan says in the letter that it's acceptable.
Yeah.
And I know sometimes you run into wetlands, those are mitigating circumstances for modification to the
Yeah, John,
setbacks in general,
I
right?
see if John
Yep.
is.
And as far as the overall surface width, that was part of the initial approval that was reduced from 22 to 20 due to natural features and the fact that it was going to be a paved surface as opposed to an aggregate surface, which the ordinance also allowed for.
Yeah, you have any other further comments besides your letter you provided?
Nope.
I got one question for you, John.
Yes, sir.
If there were another group like Fenton that was called in, or Fenton Township to fight, do they have a bigger truck that would have problems getting around that?
I couldn't speak to that, I don't know if they do or not. I know that area is primary for us, and they would be mutual aid at that point. So the likelihood is they wouldn't have to navigate that part anyway.
Okay.
I mean, does anyone, other than, you know, people are opposed to it philosophically,
Yeah.
because, you know, but my attitude is, if someone had a 10-acre parcel and had a long driveway to their house, you know, let's say that, when, you know, one of the old lots, it was a long, you know, quarter mile by 330 feet wide, it was a straight shot back, they're not gonna need more turning radius than this.
No, they won't.
I don't have a problem with this.
Yeah, so we'll entertain a motion.
I'll move to approve this plan.
It would be a recommendation of the board.
Recommendation of the board.
So there's a motion for favorable recommendation to the board for the plans that's submitted with the cul-de-sac turnaround. Is there support?
Support.
Support. Any other discussion? Okay, all in favor, please say aye. Aye. Any opposed? None opposed. Okay, you know, good, Ross? Yep. Of course. Okay.
I would note in that, if you don't mind, because if you're going based on the fire recommendation, that you do note that it is conditional upon adding no parking signs.
As amended.
If you could amend that motion to include that for consistency.
Could we just reference the letter, conditions of the letter?
Absolutely.
Let's just reference conditions of the November 7th letter.
Okay, so is that modified? We have a motion, we have support.
Motion to amend the previous motion to recommend that it's conditional upon the letter from the fire chief. Is there support for the motion?
To put no parking.
Yeah, to no parking sign.
Same motions.
Yeah, correct.
Support.
Okay, all in favor, please say aye. Aye. Any opposed? Thank you, Ross. Good catch. So, old business, item number 1, utility scale solar facilities. And where we had left off on this topic, and there's many of you that were at the last meeting we had regarding this topic and discussing solar overlays and amendments to our ordinance. And in the recent weeks, there's been significant developments in our state government. So, Mateo, I don't know if you want to provide a little summary of your guys' recommendations for us as a township. And
Yeah.
we can go from there.
Yeah, so Mateo Paslacqua, Carlisle Wortman Associates, with a planning consultant for the township. So at the last meeting, we kind of got over the hump of figuring out the overlay. And so the next step for us was to take a look at how could we define the setbacks, lot coverage, things that would specifically apply to those zones. But then also, as it related to the last meeting, I kind of wanted to go back through the language and see if it was referring to or addressing any of some of the prominent concerns that came up in public comment. Items like screening, the different kinds of financial security measures that can be put in place if the facility were to go dark or abandoned, state and federal agency reviews, things of that nature. And so the goal for tonight was to kind of put a further edited language in front of you guys, kind of go through it, field any questions, so on and so forth. Then late last week, as we all know, the state kind of rolled out House Bill 5120, which has both been moved through by the House and the Senate and now is expected to be signed by the governor at some point in time. And this is kind of the final draft that is pretty prescriptive on renewable energy sites within the state. So what I wanted to do tonight was kind of go over a brief summary of some of the bird's eye view parts of this law. We are still reading it and analyzing it and kind of understanding it, how it plays with the different communities that we're working with. And then go through the language that we put in front of you guys for tonight and kind of go through those sections, see if there isn't any other, language, questions, recommendations, but then also is the language compatible with what we know of the law that got rolled out right now? If it isn't, kind of the steps that we need to take for the next review to bring it up to that compatibility, and go from there. And yeah, so that would be kind of the next step to kind of go through this evening. And then once we have that, then we can kind of work on a further draft of the language. And then from there, once we have the language where where the township would like it to be, or the planning commission would like it to be, then I think both the language and the overlay get reviewed by, and I know there's been conversations about, a legal group that specializes in this. So that's kind of the overview of what we wanted to do tonight.
Yeah, so I guess probably the best place to start is, like you said, giving a high level bullet points of what you guys have seen from the law at this point, and kind of how does it, from our perspective as a planning commission, does it basically make our zoning ordinance null and void, or does it take into consideration what we put into place?
I think it takes
Regardless of what we have.
it takes into consideration what you have in place on certain levels. There are certain requirements in the law that are straightforward about what they consider to be a compatible law, and if it's not compatible, then there are other routes in which an applicant could go to get approval within the township, most notably going to the Michigan Public Service Commission, in which they would then review it if it's deemed that the municipality's zoning ordinance is not compatible with the law. So,
Please tell people this is not law yet, though.
no, it's
not law
it needs
for-
to be signed by the
Hold on,
government.
yeah, he said that it hasn't been signed yet in the beginning.
That's a very important part.
Yeah, it is. Yep.
So, some of the bird's eye view, some of the law is that it would go into effect a year after signature. So there is a window in which municipalities have time to take a look at what they have, make necessary amendments to come into compatibility. The size, so the sites themselves can be non-contiguous. So in order to get to the 50 megawatt or 100 megawatt thresholds that these sites are looking to get to, it doesn't all have to be on one site. To give a little bit of context for that, the law references solar sites that generate 50 megawatts or more. On average, a 75 megawatt site would need about 650 acres. And on average, a 100 megawatt site, a 100 megawatt wind farm would need, or wind facility would need about the same.
From here, thank you.
So that's just for context of, those are the sites that the law is referring to.
Question, if we adopt our ordinance and the state passes the law, will what we adopted be superseded or basically null and void by the adopted state law? Like, is time of the essence for us to get this done?
Well, the time of essence, no. The way that we understand the law is that the law is basically saying that a year after the signature, you need to have ordinances that are compatible with the state law. If you don't, then that review is just going to the review is going to go to the Michigan Public Service Commission for whatever is locally being applied for. So
So they aren't required to come to the township for approval then at that point?
they aren't, or they can, and if the township's zoning ordinance is deemed non-compatible with certain parts of the new law, then the MPSC can essentially kind of take the review away and do it themselves. So the thing that kind of relates to us is it can be non-contiguous. So again, that 650 acreage number doesn't have to be all on one site. It could be 10 65 acre sites and so on and so forth.
Does it have to be all within the same township though?
No.
So it doesn't,
So I think for us, Mateo, how I'm reading this, it's a good summary, and is that I think what we need to do is make our ordinance as best as we can, like we've been working on. Because from what you're saying, it's based, if an applicant applies for something like this in our township from now until a year after this law is signed, if it is, then what they're applying for is governed by our ordinance, because the law is not in effect yet.
Correct.
Correct? Okay.
I would agree with that, yes.
Just because I read it, but I didn't see in there if there's some stipulation where after it's enacted, any application is.
Yeah, I don't think
know.
this isn't grounds to stop progress on what we want to do with your ordinance.
but if it's not contiguous within the township. And therefore, they could, like you said, 10 65-acre sites, and it's not within our township. But basically, how are they stringing these together? It's just hooking up to the power grid, and that's how they're gonna make this, make that effective? In other words, this could completely take away any authority we have.
Absolutely.
Yeah, that's the idea.
That's why we're fighting.
It's not.
That was the reason.
Fight isn't here, it's in Lansing.
No, it's here, us too.
The reason it was proposed like that, is because of that.
Yeah.
So, Mateo, is there, okay, go ahead.
Well, so I was gonna say, so the draft language as it is now states that they may be located on more than one parcel of property, including non-contiguous parcels, but shares a single point of interconnection to the grid. The way I would interpret that is that it could be 10 sites, but they gotta be tied together and then they gotta hit the grid. Now, again, this is going on literally 2 days worth of business review because it came out late last week.
Hey, Rich, can I go inside this, because I've been kind of involved with this, because I've been working with consumers. So what they do is they can buy easements. So the easement can actually connect two separate parcels. So they can go to, if they got a parcel here and a parcel here, and there's a small area between, they can buy an easement from a different person to connect the two parcels. That's what they're doing in Fowlerville, they're trying to do right now there. So that's what they do, they just only have it, they don't necessarily have to touch, but they have to be able to get an easement to connect the two so that they can run the wiring through that location. That's how they're doing it.
But if they don't sell, then they just don't get, the government.
No, the government can't take the
Take the
easement
land?
portion, they can't do that. They can only take the actual property for the panels themselves.
Yeah.
They can't force an easement.
Yeah, so, yeah, there's a lot of this.
That's just to give you an
But no, that's
example.
good.
Yeah, for
He's the
sure.
one that can answer that question.
So Mateo, in your very brief review so far, what parts of what we've worked on so far
Yeah,
need
so-
editing that we should
Yeah.
maybe focus on?
So we want to look at, starting with section A, where we talk about the facilities at the overlay district. There's nothing in there that I think deters us from continuing to use the overlay. The regulations, the facility boundary language, I think that's all compatible. The setback language, that's non-compatible.
To what? Compatible to what?
Yeah, go ahead.
So it's not compatible to the draft law. And so originally, kind of what the standard used for setbacks is typically, a property line. And that's the way that we were going to approach this. The states or the draft law standards have different setbacks for solar, for wind, and for storage. To give you an idea, the current draft language for solar is 300 feet from the nearest point of the outer wall of an occupied community building, dwelling, or non-participating party. 50 feet measured from the nearest edge of a public road right-of-way, 50 feet measured from the nearest shared property line of a non-participating party.
Non-participating.
So
Unreal.
those setbacks,
Quiet. Oh, thanks.
with the likelihood, not the definality, but the likelihood that this language is what the governor signs, then this is the setback language we would need to use.
So Mateo, there's really no way we can prohibit out and out solar farms here.
Correct.
Under the proposed waiting to be signed into law, there's really no way we can do it. So our best strategy is to control the pieces that we can.
That's a legal question.
That's-
And put it-
Hold on.
He's not a legal,
Kurt's talking to Mateo.
I understand, but no way means there's some legal aspect to it. That's not true.
Thanks.
So our strategy is going to have to look at how would we best control it within the township, since we don't want to spend a lot of time trying to figure out how you can flat prohibit it. And the fact of the matter is, the MTA may file an injunction against this, but since it's a democratically controlled Supreme Court, which is where this could end up with in the state of Michigan, the chances of it being overturned are next to zero.
Chances.
I mean, again, without a crystal ball, you know, it's hard to answer those questions. I mean, we don't have a lot of indication that this won't get signed. And so then from that perspective, our position is that we do want to try to put you in the best position that where you are not defined as non-compatible, because then you lose control. And the site standards that are specifically referred to as the state's standard for whether you're compatible or non-compatible are some of the setbacks that I just referenced. There's language about fencing, height, screening, sound, things of that nature that would need to come into your ordinance so that if ever challenged to be non-compatible, you would say, no, it is. We have the language that's specifically referred to in the law.
Was there anything in the proposed or the law that's going to be signed regarding a bond or anything towards decommissioning that we can control?
Yeah, and it's in my notes of kind of going through the language and getting to that. I think that most of the financial security measures that you have in place are compatible. The state just refers to some different instruments of like the type of bond or the type of line of credit that can be required. So we can keep going. Like I said, I was going to go through it section by section and let you guys know what we thought was compatible, what wasn't compatible. Yeah. All right. So again, from the setback standard, it's not compatible, and this would be just drafting upon what the state has. Again, it's different for solar, wind, and storage. Again, just a quick sample for a wind turbine. It's 2.1 times the maximum blade tip height to the nearest point of the outside wall of the structure for occupied community buildings and residents on non-participating parties. I'm just giving you a sample of the way that the language is crafted. Again, it's not traditional property lines like it has been in the past. So we're going to have to take a look at setbacks. Height, it's not compatible. We have it at 15 feet maximum tilt. They have set it at 25 feet maximum tilt. Screening, language looks compatible, and we can incorporate some additional screening information in there if you want, the requirements. The fencing it's technically not compatible with the solar portion, but that's only because the solar portion references the National Electric Code for the fencing that you have to put around these facilities. So we just have to reference that. Glare, I think is compatible, or we believe is compatible. Natural feature preservation is compatible. Environmental impact analysis is compatible. Drainage and stormwater studies, those are compatible. Lot coverage is an interesting one because it's not called out in the law specifically. I think the way that they're determining placement and in some ways lot coverage is based on that setback setup, because again, now you're not referencing a property line, you're referencing a structure on a neighboring property. And so we still have to kind of wrap our heads around, is there a way to incorporate some sort of lot coverage standard that would be applicable and not put you in non-compliance? Because if they can get more out of the lot than what you prescribe for lot coverage based on the setbacks, you could be not compatible. So lot coverage is kind of out there still. Abandonment, removal, repowering, or maintenance, we believe is compatible. Decommissioning is compatible, with the exception of the language that we have right now says all above and below ground material shall be removed when the utility scale solar energy facility and or system is decommissioned. The law only references above ground. It does not reference below.
It's interesting.
Well, again, and I'm not, like I said, for me, this is good. It's still kind of being sent through our filter systems as far as what is all in the law to be considered, but that's based on our review. The security, letters of credit, cash deposit, this is compatible with the exception of the state prescribes, our language reads, the owners and or operator of the utility scale solar energy facility shall post a security instrument in a form acceptable to the township. The state draft law states that it can be a bond, it can be a parent company guarantee, or an irrevocable letter of credit. So again, what you're requiring of them, we believe is compatible. It's just these instruments have to be allowed as fulfilling that requirement. Wildlife impact analysis is compatible. Provision of manufacturer safety data sheets, compatible. The fire suppression plan is compatible. The anticipated construction schedule, compatible. Permits is compatible. We strengthened that language a little bit more to reference different state and federal agencies, and also, this is not an exhaustive list. It's not limited to these agencies for review. Photographic record was compatible. And then for the site plan approval and supporting materials, most of it is compatible. The one thing that I did want to get some initial feedback on was, if you look at 2B, it says the vicinity map showing the location of all surrounding land uses along the proposed site property lines. I wasn't sure if, sometimes if this is next to like a real small property, you might only be looking 50 feet in one direction. So I wasn't sure if you wanted to try to expand that vicinity map and what it shows, or if kind of the bordering properties was an acceptable boundary. So you can say anything adjacent to or anything within 500 feet, whether that's one parcel or 7. We want to understand what the land uses are.
It seems like it would make sense to have it within the notification span, right? Like, people would have to be notified if this was an application.
As a special land use.
Yeah,
as
it's
we're
within
in 300 feet,
feet,
special land
right?
use.
Seems
Okay.
that way we're not, someone's a property owner.
Right. All the other portions of the site plan approval and supporting materials looked good, other than F, which references setbacks, which we talked about. And then everything looks okay until if you get to L, M, and N. The one thing that caught our eye here, and I can't offer guidance on yet, is each one of those ends with the township's review and approval. I can't offer whether or not the law actually gives you that approval. And I'm only saying it from the perspective of, I'm not an attorney, but in my initial review, you may not have those approval powers. L refers to the plan for reviewing and reasonably resolving complaints from the public or other property owners concerning the construction and operation of the facility. A plan for managing any hazardous waste, which is subject to the township's review and approval. And then a transportation plan for construction and operation phases, including any applicable agreements with the road commission, MDOT. Again, review, sure. Approval, that I'm not 100% on. After that, we get to the last one, which was the batteries and accessory equipment. So the state specifically defines storage facilities and specifically states them as permissible. So we'll need to mimic that language in your ordinance as it relates to the site standards to be considered compatible.
How large, can I ask how large those facilities usually are? Storage facility, you guys know?
I don't.
I don't know if he knows.
You gotta ask me, Rich.
You go ahead.
Okay, all right. I wasn't able to find information on how big by acreage those facilities typically are. So no, I'm not sure. So with that in mind, like I said, that was kind of wanted to go through it one by one, kind of consider, any other changes or edits that you would like to see to this because the next step here is to modify this to try to get it within the compatibility standards.
Yeah, and I think when we reviewed it, we were all in consensus from what I remember, you guys can correct me, that we didn't want battery storage capability on these sites, and for a lot of reasons that we talked about. But based on what you're saying, if we put that in there, then basically one item they could say, well, it's not compatible, we'll review it as a state. And, understood, but yeah, we have a long way to go, right? Another year. Go ahead, Ross.
So again, we can come up with a draft, the best, what you feel based on what is consistent with the draft law. It is all ultimately going to go through a legal expert on the topic to kind of vet those things, and it may need to come back. All that we can do at this point is the best that you can.
That's a good point.
Gio, are you working on this for any other townships? We can't be the only one who decided to.
No, we are now, as of Thursday. Yeah, I mean, this is coming up in a lot of communities.
So we're further along than a lot of them are?
No. I mean, I would say, from the perspective of being proactive on trying to strengthen your ordinance, yes. There are some townships that don't have any language at all that are they're gonna try to figure out, well, what makes us compatible, what also protects us from what's important to the planning commission and the community. You guys have established a lot of that framework already. It's not done. But a lot of communities basically just got given a year notice to figure this out. I think you guys are a lot further along.
It kind of seems to me that we should move on this quicker than delay, and to get something done and at least have something in effect, so when this comes up, we at least have something on the books. I'm worried about people are going to come up with this after the governor signs it, and they're like, well, that was kind of ex post facto, you were trying to address it, and you're going to have a weaker case if it goes to the
Well, you have a year. It doesn't go into effect until a year after signature.
Yeah, but
no, right. That's not our timeline. Our timeline is more or less
litigated.
No,
we are currently still under moratorium.
Right, your timeline's your moratorium.
Yeah. Then I would like to keep this going forward, for sure.
No, for sure.
If the board can justify that, I'm sure they could try to extend as well, and that's going to be part of the legal counsel on it as well.
Well, it's better to get something amended and out there again. We have an ordinance right now, but we need to get something out there, and then if we have to amend it later, that can be done.
Yeah.
Yeah, so one of the,
I think everything that Mateo said as far as us being compatible with what we know, we kind of need to adopt, otherwise we're going to have a problem right out of the box.
yeah, so the one item on, brought up on decommissioning, if you put in there stipulation that the soil is, I think in the current ordinance, we have that it's returned to a usable state, is the language we have, something like that. Some type of test that proves it before they walk away from it.
That's in the draft language we have.
Yeah.
Environmental correct.
No, it's not.
Well, it says it'll be, I think it's removed or something. It says it'll be removed, but it doesn't have anything like, hey, there's no issues with your, like similar, like if you had an automotive shop, when you sell that property, you got to
I'm confusing it with the initial environmental impact study.
Does that make sense, Mateo?
Yeah, I mean, from the perspective of you're saying that you would like to add the soil reference, or are you asking if the ground shall be restored to its original condition covers that requirement?
Yeah, that's what I'm trying to, because what you don't want is, like, a lot of times, if you sell something, someone gets it, it's
Right.
thousands of dollars to do
Right, I mean,
remediation.
I can look at, like, if there's some language that we can add in there that basically, like, says, including, the environmental status.
Exactly. Yeah, but does the state law override us?
Well, let's not worry about that. We got a
Exactly.
year to plan it. Why not get what we need?
He just said the state law only requires the top.
So,
Then we worry about it in a year.
Yeah.
There's gonna be all kinds of.
so for us,
lawsuits.
Mateo, for us, the feedback, what feedback specifically from the planning commission are you looking for at this point?
I mean,
I know we just gave some, but we want to make sure if
yeah,
that we're clear.
I mean, if you're comfortable with, like I said, the language got changed a little bit, and some of it's still applicable, because again, a lot of these edits were made before the law came out, and we wanted, before the draft law came out. And we wanted to kind of go through with you, but if the draft as it is now is acceptable, then we'll use that language and modify based on compatibility issues or concerns that we have, and have that ready for the next review.
Yeah, and for me, you guys chime in, but I think, to me, we should keep the setbacks. How we, as a township, what we want them as, right? Because I understand, Mateo, they might come in and say, hey, but at least we have some type of, hey, this is what we intended this space to be used for, if it goes to court, wherever, right? That we have
Across the
something to
board.
go back to.
Well,
Right.
yeah,
Because we started this and we're working on this long before this bill came about, right? So that's kind of, I don't know, I understand what you're saying.
No,
The
and I-
recommendation that, hey, you're probably gonna get overruled if this is the law. I understand that.
well, and again, and it's good that a part of this process is gonna be including legal review
Yeah,
with expertise.
absolutely.
Our interpretation of the law is just to make sure that you understand that what could happen there is that it's not about getting sued. There isn't a process for that. It's the commission
State
needs.
just says-
You lose your control of
The
the
state just says
Public
you are
Service
not
Commission comes in
compatible.
and says,
You've
this is how
lost
it's gonna work.
your review control to us. So I just, because you know, we might get sued over it. I just wanna make sure there's like that process won't even be there under the draft language.
Are you saying that if we keep our setbacks in there, that we could lose control because of that specific item?
Yes.
Well, then,
But
Now,
you change it.
wouldn't the Public Service Commission just come in and say, they would just redline the part of the ordinance that they feel is inappropriate? If they said the setback is supposed to be 25, or the height's supposed to be 25 feet, and you got 20, it's 25. But they wouldn't come in and eliminate the whole ordinance that we have. They would just redline that portion.
Well, let me, give me a second here.
Because I couldn't see them throwing out the whole ordinance because it says 25 feet instead of 20.
Yeah, I just
are
wanna.
they gonna go through and review every single township's ordinance to make a case-by-case basis, or just go through and
If it's challenged.
approve them all?
There's 1,760 townships in the state of Michigan, so they got a lot of work to do.
I'm gonna bet there's
It's
gonna
challenged is
We
all
need
I
you to
have.
stand up.
Approved as-
Approved as case by case as challenged.
As
Not they're
challenged.
going to go through and vet every single one.
Well, the MTA files an injunction too.
So a compatible renewable energy ordinance defined in the draft is an ordinance that provides for the development of energy facilities within a local unit of government, the requirements of which are no more restrictive than the provisions included in section 226.8. 226.8 is the setbacks that we just talked about, the 300 feet from a building. So if you don't meet those standards, then you're not compatible. And if you're not compatible, you can go to the Michigan Public Service, they can go to the Michigan Public Service for review. So
I just can't see them overturning the entire ordinance. I can see them,
and that part, I didn't sense any direction from the draft on whether or not they would throw everything out, or they would just throw your setbacks out and say, everything else is fine, but we're gonna take over the setbacks.
because typically they would redline the section that was, they felt was, I don't want to say unconstitutional, but not in compliance with what the state law says.
Sure.
Or they could just say, the state has this set of regulations, it's it's designed to that set of standards, here's your approval. I think there's gonna be so many these things going forward, that they're not gonna have the time to go through every single township ordinance. According to Kurt, what, there's 1,700 townships?
But then
I can't see them,
they do get the Public Service Commission will get a year for review.
each application?
So,
Yeah, so
Like,
understand your
there's-
point though.
yeah, I just, like I said, there's some things that are direct answers, there's some questions that doesn't.
No, I think, I mean, if that's our recommendation, then I'd say we recommend the board that we keep our setback language in and let them make the decision, give them the argument. You know, give them the argument that this could.
Yeah, and then the other part that we have to, originally would say, hey, we don't want battery storage, but if we don't have it in our ordinance at all, any suggestion of it, then it defaults
Yeah, I mean,
potentially to that.
our job is to get this where the planning commission wants it, and then once it's there, then it goes to a legal review. In the timeline of things, you just keep in mind that if legal review can say whatever they'll say, if they send it back with a lot, we've got a lot of work to do.
Yeah, because see, the Public Service Commission is totally different than any place else. They're granted the authority to make changes, and they can do that without, without having to go to court to do it.
Right.
One other question too, real quick. The overlay that we have developed is based on the future land use map in the master plan, which hasn't been approved yet.
Right.
So can we address that in the ordinance if the master plan hasn't been approved by the time we get the ordinance ready to go?
Well, I think you're quasi confusing two separate things. The future land use map was what we were referencing when we were trying to figure out what we wanted to do with the overlay,
Right.
and the justification was that we want this to be planned industrial, we consider this an industrial use, that's where it should go. It would be adopted on your zoning, or like on your zoning map.
Okay.
So the process of the master plan doesn't really overlap with.
So we can proceed with the overlay as we have designed it under the future land use map, because that's the only thing I was worried about, because if we got the ordinance done before we got the master plan officially approved.
Yeah, the overlay needs to go over your zoning map, but the future land use map uses parcels.
Right.
So it won't be.
So
anything-
could we, for the next meeting, when we discuss this, have that on the zoning map, just to have it?
Well, their drafts are already on the zoning map.
They are, okay, because the one we
That's based on the
had was
existing
on-
zoning map.
Okay, so I just wanna make sure we're not,
What are you talking about? The overlay geography itself is based on parcels, which exists on both maps.
Right.
So the overlay as it is on the future land use on the zoning map, parcel wise is the same.
Okay.
That's a statement, that's a statement. So.
We just call it one thing in one map and another
Yeah.
thing in another.
Well, it would be this overlay in the zoning map,
Yeah.
and it would be, once you get to the point of adoption, it would be on your zoning map with this language,
Can you show the overlay map?
Yes, can we please see the overlay maps again?
Why are you looking at that map?
That's what you settled on last meeting?
No.
these are drafts, that's why I'm saying, if we, for the next meeting, we have the finalized one, that way it's clear what we're talking about when we're
Was the last one
presenting
in
this.
115 Road?
Yeah, yep. Because
Because
what
it's the
we-
two sites.
was smaller. What we decided on the last meeting was much smaller footprint than
Yeah.
what's shown right here. So.
And
Do you have a picture of that so we can see what was decided on last meeting?
No, I don't.
We can go to the website and go to the last meeting packet and bring it up that way. But,
Could, yeah.
That would be nice.
But it's this.
That's it.
Right there.
Well, that's one.
That's all it is.
That's one,
That's one.
yeah.
Where's that located at?
That's what I'm saying, bring it up.
Took it down.
There's two ones, it's all the planned industrial on your future land use map. So there's two, there's one south of ITC and north of ITC.
Yeah, so we've got.
What parcel is that?
Change there, and then the boat.
Right there.
Outside
Right
of
there.
the
But yeah, it'll be better if we have it.
We'll look at it.
Oh, yeah, no, you did by the plan.
So from the ordinance language, I don't know, comment about the soil testing when it's decommissioned. Put in there.
Yeah, that's what we had.
We have to agree if we wanna, what, we're, like these setbacks, or we leave it, says we want them to height, I know the things he mentioned, that we should give the direction and the tail for those.
I think if we leave those, if we leave our setbacks in there, we need to put a footnote or a note to.
Well,
Or that
like
this is gonna
Mateo
go
said,
to
it's gonna go to legal.
Yeah, it's,
Okay, so if that's the case, then.
yeah, so it's gonna go to legal review before it gets,
Let's keep it in and see what happens.
Yeah, and
just as long as we know.
yeah, and Mateo is giving us the heads up, right?
Yeah, could be about
We're supposed to, yeah.
Yeah, but I mean, like I said, we're getting to where you guys want it, you know what I mean? I'm just
But
offering my walk.
from the battery storage perspective, I think for us in our township would be good to, you guys chime in, is that we say they're prohibited because we don't have the capability to contain if there's an incident, right? And then that maybe gives us standing that maybe there's a huge applicant here and then they can be part of getting the fire departments what they need to take care of a fire if there's such an event, right? Whatever it's chemicals, whatever that is.
Yeah, I mean, we've got,
Is that a possibility that because of fire hazard, that we don't have water out here that we could, that could, the fire department could put the.
Well, I just say, my point is
I mean,
that,
battery fires are beyond water too.
Yes.
yeah, no, my point is that we don't
Yeah.
control that, but if we put something saying, this is the reason we prohibit it, then it has, it puts the onus on the applicant
public
to say,
safety.
hey, I'm gonna address that.
At least there's some
Whatever
justification
gets in.
there, something to go on, other
Yes.
than we don't want it, right? You know, that makes a lot of sense.
Yeah, we can push the envelope a little bit.
Hey Kurt, this attorney you guys might bring on, he's gonna probably set us in a whole different direction too.
Yeah,
Well, he
we'll
might have
see,
a lot
we'll
of
see.
different, well,
Hold on,
I'm
let's-
saying, what I want to say, he might have a lot of different ideas for us too.
It's possible.
Yeah. What was your comment, Mateo? You
Oh,
can
yeah.
say, very good.
no, I'm gonna say,
Okay.
Everybody's a junior attorney here.
Nobody's talking.
And then we wouldn't have to have them.
So the setback and the height,
so,
we leave as is, or what's? the-
yeah, so why don't we, let's, if you don't,
Go
let's
through,
do
yeah.
this, let's just, the non-compatible stuff, you know, stuff we feel is not compatible, let me get direction from you guys. Do you want us to draft something more compatible, or you wanna leave it as is, whatever it might be? So the first one that falls into play is are the setbacks. You know, the way we have it set up is we were looking at basically setbacks from the property lines adjacent to residential uses, institutional uses, schools,
Yeah.
churches, and then everybody, you know, all others. That's the way we had it set up there. Do you want to modify this in the perspective that's compatible with the draft law, or do you want to leave it as it is or change it some other way?
No.
Yeah, I think I would rather it be as large as it can be, but what's
For
that?
clarification, this is inclusive of wind as well as solar that we're discussing, or specific to solar?
Well, so, that's a good point, because I mean, the special land use itself is specifically referenced
This
to
is for
solar
solar, what we're
facilities.
working on, yes.
Yeah.
But I know the state law also addresses the wind, and I'm not fully, I want to make sure that we're on the same page, whether or not that plays into our discussion right now.
Yeah, I mean, again, I guess it goes more to the case of how perceivably compatible do you want to be? So we're just strictly talking solar right now. Wind, you know, we could develop setbacks based on a wind facility that are the same as the states. We leave it out. It's kind of, again, at your discretion. I would say if ultimately this goes through an official expert legal review, that maybe the resources are better spent when it comes to the wind question, and is let them guide what they believe the next step is, as opposed to having us draft up stuff that might get torn up anyways.
Yep.
That's,
Yeah, I agree with that.
It's logical.
so as it relates to solar, then do you want to, how would you like us to address this?
For the setback?
Yeah.
Yep. So you guys can see what we have here. And to me, the 100 feet is a reasonable.
Let's keep our
but
setbacks in and see what the legal
yeah.
says.
What are you basing it on? Do you know what you're basing it on?
Yeah, the worst they can do is tell us to change it.
Because that's more restrictive than what we're hearing that the state's proposing, so I would say we leave it.
Who put those setbacks
The height,
Yeah, so the height, we have 15 feet, maximum tilt they have 25.
yeah, I wouldn't. You get 25, that's high.
That's real high.
To me, then you're not
Let's keep our
screening.
let's keep our
To me, I would keep the 15, but what do you, how do you feel, Kurt?
You know, they could make us change it. That's the worst thing we can run into.
Keeping it?
I have
And
no
it-
idea what the
It doesn't
typical
matter
height
what we
is.
put. That's what everyone has to realize. It doesn't matter what's there.
Yeah, but we have to try
Does
and
matter.
see
They're
what.
gonna, they're gonna,
Kurt, when you said they, that's what you mean, the legal team will review it?
Yeah.
Yeah. All right, screening, so leave the 15 feet?
Yeah.
Okay, all right. The fencing, again, I'll read it to you just so you guys know. The fencing for a solar facility complies with the latest version of the National Electric Code as of the effective date of the mandatory act that added this section or any applicable successor standard approved by the commission is reasonable and consistent with the purposes of this subsection. I take that as whatever the national code is the standard that they would expect. We've got, you guys have fencing, you already have fencing language in your ordinance, which is what we just had them refer back to the 6 feet.
for non-residential, it could be up to 8.
Okay. So with that, you want us to change it or leave it?
So I think on the screening part of it, we say adjacent properties and
Screening.
the beginning of the ordinance language. That is obscure from all adjacent properties, like, can you put from on all property boundaries, or, I don't know,
From the perspective of
from road right away.
Every-
Basically, the question.
every property line it's screened from every property line.
Yeah.
Day 125 feet. Sorry.
Alright. Fencing? It's the one where we just, the
Yeah.
National Electric Code? Or what you guys have?
Yeah, to me, like this leaves it to the planning commission
No, it doesn't.
to decide this, right? The language here does.
That's
No.
specific to
To
screening.
go to fencing at the end, right?
Yeah.
You can require additional, but as it's written, but.
And then they're gonna fight you on it, because you didn't have it laid out in your ordinance.
Got that much room sitting around, I think. I think that 12-foot fence is from Brewery, I don't think.
Is fencing part of the security process?
It's not, the security, not necessarily, I mean, whatever security measures that they would want to take for the site.
Are we just trying to keep the deer and the antelope out of there? Or
They
are we
won't stay
trying
out.
to keep the
I think it's
People,
anything that's not supposed to be there.
so I guess, part of that, I guess, is maybe should be addressed under security for the project. I guess,
Well, I guess for me, it can be a part of a security measure, it can be part of a fencing measure.
well,
What we're trying to compare to is, do you want me to, regardless of where I mention it, do you want to follow the national code that,
does the code cover security around the developer? Because if it doesn't, it should.
I can look into?
Why not follow the successful ordinances out there?
Screening or fencing for security versus fencing.
Yes.
What we have the ability to do. I think screening for the aesthetic purposes the screening for aesthetic purposes is a big part of it, but security is also something that plays into it. I think there needs to be some kind of differentiation.
So basically, I guess I'd like to see a security plan for the development.
And would that be separate from the screening aspects? Screening would be above and beyond?
Or it could be-
You know, it might be and it might not. I guess there's two ways to look at the fencing, is exactly what you're fencing something for, is to make sure that it has limited access, but also that wildlife and whatever all else is not going to interfere.
So I think that's what we need to really get clarification on, is whether the fencing standards specific to the national standards that you referenced are for security, or if it is.
Yeah, so I guess one of the questions is,
encompassing.
should we have a security section in there that addresses,
Well, I think that you could probably add that type of language to the site plan approval, like supporting materials, if you want to see a security plan for the site. And then we can look into, is the code that's referenced in the draft, what are the standards applying to it, and does it reference security itself?
consumers has signs and everything around their towers and stuff? Why not find out what they can do for that?
Sure. Okay. Let's see. Lot coverage, again, this is one where we have it drafted to where, the total amount of lot coverage that can be utilized by the system in any accessory structures is 75%. With the way the setbacks in the draft law are set up, again, being measured from the point of adjacent buildings, it gets really site specific as to how much space of the site they could actually use. You could leave the lot coverage in there, but if per instance, it comes up as being more restrictive than what the state's applied, you could put yourself in a challengeable position. So lot coverage is one that I guess I'm kind of waiting to see a little bit more dust settle on the conversation about.
So in the way this is written, the panel itself wouldn't be considered lot coverage, right?
Yeah, it
Just
would.
the footing, mounting pads, driveways. Just trying to make sure we're not missing that part of it.
The footprint of it is going to be the mounting.
Well, you know what I mean, but if you have a
So for
3x3 base.
So, yeah, it says
supporting-
that the impervious surfaces, for the purpose of calculating lot coverage, would include, but are not limited to, mounting pads, footings, concrete, asphalt driveways, walkways, accessory structures. I think we could put it in there to where it specifically states that the
Panels.
panels
Yeah.
themselves are part of that.
Canopy of the panels or something.
And again, that one that I think will get deferred
Yeah.
to the review committee pretty much. For the decommissioning, I know we had talked a little bit about including some original, like the state of the site going back to maybe its original environmental state. There's language about that. Then there's also the all above and below ground materials. So again, the state draft law only references above. So do you want to leave below in, or do you want to take it out?
Leave it how we wrote it.
I think it should all come out.
You're gonna buy that one.
Hard to get a plow through all those wires.
It might be something the state didn't even consider.
That's the growing pains of these things.
They knew exactly what they were doing.
What was the consensus on that?
These are the way we wrote it.
Leave.
It's all gonna come out.
Yes, I like it how it's written.
Okay.
Which one?
The decommissioning, it says all above and below ground must be removed.
That's right.
Yeah, the draft law only references above. That's why I'm asking.
That's why.
So I guess the question is it more restrictive if you say underground too?
Yes.
I would lean yes.
Well, underground, meaning the footings, stuff
Yeah.
like that. Like, whatever, they're not gonna come with an excavator and dig it out, right? Is that what we're getting at? Or are we talking about the actual concrete that the panels sit on? All
We're
that?
saying you want
Underground cables.
Uncontaminated soil.
I think
Exactly.
that needs to be,
Replace the topsoil.
Uncontaminated
I don't think
soil.
they're gonna do that.
Well,
but
exactly.
to get
It's
everything
worthless.
out of the ground would probably be the best.
We can put it in there.
Yeah, so it sounds like
Leave it as
is.
Okay. Then we get to the security, letter of credit, cash deposit, things of that nature. So again, the language references, letter of credit, deposits, a security instrument in a form acceptable to the township, equal to 150% of the total estimated decommissioning, and or reclamation costs.
Is the word security there, should that be surety as opposed to security?
Or financial security, it can.
Yeah, but I mean, that leads me to believe, if I look at security, I think about a fence and access. I don't think about the letter of credit and cash, so I think it's more of a surety.
Surety, okay. Yep, so we can do that.
And that would also go for number 4 there, surety bond, S-U-R-E-T-Y.
One other thing, my apologies, I never got to this part of my notes. The state does have draft language establishing basically increments in the percentage of these financial sureties, and I want to, give me a second, I have it, I just want to be able to read it to you guys. So, however, the financial assurance may be posted in increments as follows: at least 25% by the start of full commercial operation, at least 50% by the start of the 5th year of commercial operation, and 100% by the start of the 10th year of commercial operation. So they have steps as to what you can make them put up front over the process of time.
Yeah, you'd have trouble fighting that one.
And the original subsidies are gone. We'll never see the money.
Financial assurance level profile will be low, should be not less than the estimated cost. Yeah, so the amount of the financial assurance shall not be less than the estimated cost of decommissioning the energy facility after deducting salvage value as calculated by a third party with expertise in decommissioning hired by the applicant. However, the financial assurance may be posted in the increments. So to me, it says it can't be less than 100%. It doesn't say it couldn't be more. So I think your 150% amount is fine. Do you want to incorporate the step language, the 25%, the 50, the 100?
Yeah, we could do that.
I kind of don't like that, because if if the incentives do go away, if this thing turns out to not be as financially viable, or, you know, something should happen, then we're gonna be stuck with these things that people are gonna go bankrupt on, we're not gonna be able to get them cleaned up. And
That's exactly what's happening.
I really think that, I mean,
Yep.
you're already seeing, at least in the automotives, where they're starting to pull back on their prediction of how many of these EVs are gonna sell, and this thing, to me, is gonna be the same thing. It's gonna, you know, they're gonna go at 110 miles an hour, and then they're gonna find out, oh, it's not actually working, and then
Sure.
it's gonna be half built out there, and people are gonna be going broke, and we're gonna be sitting there looking at this, figuring out how they're gonna fix it.
It's happening with unemployment security commission right now too.
I mean, again,
I think at least 50% initially, at least out of the box, or more, because they're saying 25% upfront.
they're saying 25% at full commercial operation, so when they start. 5 years later, you get 50%, and then you get 100% in the 10th year.
Let's see, 50, if it was up to me, 50% at permit and 50% at city.
But that's an operating cost, that's not decommissioning cost.
That's what Cummins, I thought.
Well, it
Right,
says,
but what the law states is operating cost, is what you read there.
financial assurance in the form of a bond, parent company, or revocable just by cash. The amount of the financial assurance shall not be less than the estimated cost of decommissioning
Okay.
the
I didn't
engineer.
read the.
And all they're talking about is the bond, putting up the bond. not
Well, the
actual
security, yeah,
cost.
the bond, the irrevocable letter of credit, or guarantee from a parent company.
The bond necessarily isn't the total amount of the cost.
So the two
It's
things,
the bond.
yeah, the two things I guess the two things to consider there is, do you want to incorporate the step system that the state has, or a different one? Do you want to leave it as is? And do we incorporate the instruments prescribed by the state? Bond, parent company, irrevocable letter of credit.
Well, the instrument is less of a consideration than the
Steps.
whether we go on a step basis or whether we go up front and ask for 150. I would guess that if you ask for 150 to start with, that's probably going to be a non-starter for the Public Service Commission right there.
I mean, yes, yeah. I mean, it's, again, by definition. Well, now here's where, again, we'll see when it gets to the legal aspect of it. The state defines non-compatibility as 226.8. 226 is the setbacks, the height, the sound, things of that nature. This information isn't in that section. I don't know if that means that can't be considered for non-compatibility, or it still could be considered for non-compatibility. What's wrong with us? I know, I do the same thing trying to read this.
Yeah, no, that makes sense. It could be something that we're fine to be more restrictive.
Right, I mean, it might be that section 226 is all they use to define whether or not you're compatible or not, and these other things are more give and take.
Yeah. So it's up to us.
Well, like I said, it's going to get reviewed by somebody else
Right.
anyway, so leave it in.
So,
Leave it as is, everything, okay. I mean, I think that, it says here forms acceptable to the township. As long as you're acceptable to these things, then we don't have to add in all the different types of securities. And the step system, you can leave it at the 150% and put it through the ringer.
We can make it as restrictive as we can within our ability to do that.
Let's see, the next one. Was the all right, so then the next ones were those, some of the site plan information where it's the language about reasonably resolving complaints, managing hazardous waste, and the transportation plan and construction. That language at the very end of each one of those that says township approval, review and approval.
to me, we leave it in there. That's very consistent with all of our other ordinances, right?
I mean, I would go with, or, we would go with the attorney's review on that.
Yeah.
And then last but not least is the battery storage at the very end.
Yeah. I think we should prohibit it.
So language stating,
Yes.
Yeah. And I think we should state that because of, I mean, I know that they don't put all the water, but because of we don't have municipal water, we could say that, it's a public safety issue, we don't want it.
Yes, we can include as much justification
We
as
don't have to
possible. We
ask
can
that
include it
for
ourselves.
There you go, yeah.
We have our wells.
We've got health, safety, and environmental concerns.
They don't know how to fight them.
okay, you guys have given me direction on this.
So we're gonna come up with then something in security to put in this in regards to fencing or keeping people out or locking
Yeah, I mean,
them
I
in
think it's fair to add a security plan to the site plan.
there. Yeah, ask for
requirement.
security.
And then we'll look at what that national code for that fencing
Yeah.
is. And we can kind of come back with where we can put some language in that I think works along those lines. So,
Sorry we drug this out so long.
no, I mean, I appreciate that's
It needs to
on
be-
short notice for how quickly things came about. This has been productive for us, so that's good.
A lot of moving parts.
Uh-huh.
It's a lot of moving parts.
Yeah.
Any other items? Two on the scale for tonight? Okay. So, move to call to the public. Go ahead.
Sorry, you go.
I'm going first. Okay, Kim Procolosi, Deer Park Court. I want to say that I applaud you for sticking with what we want to start with, because it's likely a 2-year process, and in the short term, let's get what we want. Somebody can always come in and say you can't have it, we can change it. They're not going to come in within this period of time, and I have a little experience with this, with the whole asbestos world. When there was fighting that went along, right, you had all the rules that the government put in place. I worked and lived in Arizona for a company, Greyhound, that had a big asbestos issue with brakes. And by the time it went through all the courts and the system, it was a very different policy because they learn a lot as they go along. And there will be some fights and lawsuits with different townships for different reasons. Ours in particular, water is a big deal. So the leaching that happens from this stuff is very, very important. And I think at some point, that's gonna matter. So it's important to do what we believe is right for our township and have a record of what we believe is right for our township. So thank you for doing that, because I think it's important.
Thank you, Kim.
Jeanette?
Okay. I'm really disappointed. We spent all this time tonight and money talking, and again, Mateo, I'm not gonna take this personally, he works for a company that is pushing an agenda to push this stuff. So when he keeps telling you about the law, etc., it is not law yet. It hasn't even been signed. It still has a year from the signing. And there are townships already talking about forming coalitions together to sue. Plus, you mentioned the MTA as well. Now, do any of you guys know what happened in Ohio? Do you know what's happened? So here's my other point. You guys don't know what's going on. You look at Ohio and they did these same laws. What happened there? The people rebelled about it and put up so much fuss with so many lawsuits that they stepped back and they are no longer telling them what they have to do. So stop giving up to what this government is telling us that we need to do and fight for us, the people. This, in my opinion, and I agree with you, Kim, what you said, there's still so much in there that's not strict enough. I came to a meeting, I showed you the ordinances that are out there. They're solid. They're townships that are right beside us. They've had legal in them. You guys could have picked and choose from all of them and looked at them and said, hey, this sounds good, let's put it in, this works with our. But instead we're relying on somebody who keeps telling you, oh, the law, and this law's not even in, and up until today haven't heard him say it, but the threats of, hey, you're gonna get sued, which isn't happening. And so I understand that something is coming down with the state, but You guys need to stand up and say, this is what we want for our township. Now, Rich, you said when I talked about and pointed to what I asked you to put in the agenda, you said, oh, we're gonna talk about that later. You never once brought it up. So I'd like to step back from public comment and have you address the items that I asked you to put into the agenda tonight. Because you said you were going to, and explain why you didn't put them in there. So could you do that?
No, I said we were gonna talk about this topic, and I think we talked about a lot of the items you mentioned, but specific to that, if a planning commission member, they all got that email you sent me, I sent it to them, and if we wanna put it on the agenda, it would be in miscellaneous business, right? That one of the planning commission members, as you mentioned, in your
Okay.
first public comment.
So I'll still wait for one of you to step up during miscellaneous business and say, let's look at this resolution, okay? The other thing, the mention about the lawyer. This lawyer, and a couple of them that have been recommended, you keep saying it's gonna be thrown to legal review. That's not how they worked with these other townships on this. They are subject matter experts. They will help you all along the way. They will attend meetings even. And I'm sorry, but we don't need Carlisle Wortman telling us what the state might do in a year to 2 years from now. We need to know what our township wants and what we feel is valuable and write that into our ordinance with the assistance of a subject matter expert / expert law firm. And I ask that you guys would get on the supervisor and say to him, we want to see proof of the ordinances, the copies of the ordinances, solar ordinances that he's put through. The other thing is the wind ordinance. You have to do that one also. That's a whole different story. So, you know, you can tell me to sit down anytime you want, but I have some more things to say here, and I'm disappointed that the solar overlay map is not available for us to see. We're all questioning, what is that property? And I said to the board, and I'll say to you guys, if any one of you have property around those areas, have family, know anybody, have connections, you need to disclose that and you need to recuse yourself. There's huge money in this business. People are getting paid off. And I'm just saying, if you have any connection, you need to let it be known now. Also, errors on the meeting minutes. I hope that you're going to rescind that approval and allow me to submit what the errors are. Sorry. I've lost my, look at all my notes here, you guys. I'd like to have a longer audience with you, but, okay, so a few things. I don't see noise being addressed in there with the inverters. Is that noise in the?
There's no noise language.
Okay, come on, this is all over the
All
place.
special land uses are required to demonstrate that they do not produce nuisance factors. Noise is one of those included nuisance factors.
What's the level for noise
For
nuisance?
all special land uses.
What is our level of noise?
Anything unreasonable as determined by the township board or in accordance with our noise ordinance.
Well, how many decibels?
That's in accordance with our noise ordinance.
We need it to be, it doesn't state how many decibels though? In the
It
noise?
does in our noise ordinance.
Well, that's, I'm asking you, what is the decibels in the, what is it?
There's different categories, there's different time frames. I don't have all of them.
So what is it for solar facilities? If you go up to Lennon, you will be horrified, and the gentleman that suggested that you take a drive up there, I'm telling you, take a bus trip. You will change your mind. You will say, we will never allow this in our community. We'll do whatever we have to do. I understand that they're coming after us, and they are coming after us. We know people already that are signing leases, okay? So for whoever said they're not here yet, they're here. They're here.
Are they signing leases here?
Yes, they are. Okay, so again, I'm just really disappointed in the time wasted. Not one of the planning commission reached out to me to say, hey, Jeanette, could you at least send us the link to those ordinances? These are ordinances that people have worked hard and long on, and they make sense. But instead, you guys sit here and guess about you know, like, oh, 15 feet, 20. You don't even know what you're comparing it to. Like, why do you think 15 feet is a good height? Where do you get that information from? You know what I'm saying? So I've immersed myself in this the last month or so. And I'm amazed at what I've been able to find out about what's going on. And I feel like your knowledge is sorely lacking because I hear you say things that make no sense at all. And Mateo, you gotta stop with the comparing what the law is. I know you work for, your company, and that's who's telling you what to say, but we don't care. We don't care what the law says. Or it's not a law, that's the point. It's not a law yet. There's gonna be lawsuits. People are ticked off. We don't want our rights taken away, and we want a commission that stands up and stands up for the people. So take a look, please, at that resolution. You guys could redeem a lot tonight by passing it, putting it through, and saying, we stand up for the people of Tyrone Township, we stand up for our rights that we've always had, and we do not want the state taking over our rights. Sign it, boom, and it's done. Thank you.
Thanks, Jeanette. Scott?
Yeah, I'm sorry that Mateo got pretty beat up there.
I'm not beating him up.
No, but you know what? I sat there and listened to their questions, and I don't want to make a fight of it, but they asked him what he's been through and what he knows about the law. And he already said he wasn't an attorney. And he was trying to explain for what he's worked on so far. He's not pushing it. I'll stick up for the man for that. He's not pushing anything. So let's stop beating up on him. He's trying to help us. I mean, we don't want to beat up on him. He's trying to help us.
You know what?
But what I'm saying, we're not going to get anywhere beating up on people.
I'm not
But
beating
he's not a lawyer. Jen explained it
That's
to me.
right.
Okay, but this is what, we're not going to get anywhere unless we learn.
If you want to keep allowing him to address me,
Okay, that's fine, that's fine. But I just wanted to clarify that,
well, I'm going to clarify
Go
back.
ahead, Scott.
you had your say.
Address the plan.
I'm going to clarify back.
I was
You pointed
talking,
at me again.
I was talking to him, and you alerted us.
Stop talking to me.
Address us, Scott. Thank you.
There's a bunch of school board meetings.
Go ahead, Scott.
Anyways,
Oh, that you.
thank you for helping us. Thank you for helping. I do know, I've been in enough meetings that we could beat up on these guys all we want. They're fighting the best they can. And I mentioned this earlier. The state controls more than we can control. What they're trying to do here is trying to mitigate as much as they can within what's coming. We don't know yet. They pretty much said, we don't know yet. The laws haven't been changed. So hopefully, but yeah, we can go to court.
Yeah,
We can go
Thank you.
we can go to court.
Thanks.
We can go to court. But the lawyer that we had here that represents our township already told us, how much money do we have? How deep are our pockets? Because they got a hell of a lot more money than we do. So let's keep fighting to try to make it as less painful as possible. I want to know if there is anybody. I would imagine if there was anybody signing leases, they wouldn't let it out because they don't think they want the harassment. I want to know some names if they are actually doing it.
No.
Public information.
Well, we've heard it here tonight, but I haven't heard nothing. I hear a lot of things, but are they true? Okay, so this is what happens. People put stuff out there, and it's not proven. And then this is what happens. And then everybody gets in an uproar and gets in a fight. And this ain't gonna help. All right, so let's get, the biggest problem is, and I said it before, here's a perfect example. We got 4 guys here. If we had one less guy, we wouldn't be able to get nothing accomplished.
We didn't.
There are certain people on this panel that don't come to meetings. If we keep getting meetings canceled, not here live, but the board, we're not getting nothing done. We're not getting nothing done in this township because of all the cancellations. I mean, this lawyer thing could have probably been resolved meeting this month. Could have been taken care of. So now we gotta wait till what, in the next meeting? So I mean, we got business to do. And we're not getting it, gentlemen. But like I said, not everybody on this board is fine. There are certain people, we got people in the audience here that come more than some of our board members. And if they don't want to come and work, they need to exclude themselves, and let's get somebody up here to work.
Thank you, Scott. Any other public comment?
I just want to say something.
I don't know, I couldn't see.
I don't public speak, so, and I'm new to this area.
Please state your name
And
for Ross.
Sorry, Tina McCalla.
Thank you.
I live on Riverwalk Drive. This woman right here, and I will point at you, should be the consultant, not this. No offense. She should be the one that you're consulting. The other township should be the one that you're consulting. Conway Township should be the one that you're watching. Because they had a huge turnout and huge uproar about solar and wind and everything. They're the ones you should be looking at. Drive up north, look at the solar, or look at the wind turbines. Specifically at night, when all the lights are blinking on and off, on and off. I don't know how people live with that. I don't want it in my area at all. I don't want solar in my area at all. I don't want to drive out of my beautiful wooded area, come out to solar panels. I don't want it. And I don't think a lot of people around here want it. It looks like you're all basing it on a law that isn't even passed yet. We're basing all of the things that we're writing down is all based on a law that's not even passed. A law that's not even signed in. I think that we need to get a little bit of a backbone. Put forth some solid things that your people want. We don't want it. How many times do people have to say we don't want it? It's plain and simple. I don't care what the state wants. We'll deal with that later. We don't want it in our township. Period. Period. Get a lawyer. If you're gonna consult with somebody, not us, get a lawyer who has experience in these other townships and consult with that lawyer. That's who we should be talking to. Not trying to finagle our rules to abide by the state. That's not how it should be done. It should be us taking a stand. Somebody has to take a stand. You guys are here to take a stand for us. And if you don't take a stand for us, then we get rid of you. And someone else gets put in your place. But I'm telling you, right here is a resource, and you should be checking into it. I've watched you guys on the videos a couple of times, and here I am, because I was floored. I want to see action. I want to see the person that's representing me, which are you four, actually represent me. Speak your mind like you mean it. Not be coerced by fear. That's not what we're here for. We're here to make rules based on what our people in our township want. What we want. Not what the state wants. Not what anybody else wants, what we want. And that's what we should be doing.
Thank you. There's a couple people that were standing up. Who's next?
I was just gonna, Holly, I must say, how general, I was gonna ask, who's the lawyer? Is the environmentalist lawyer? Do you know? Kurt, do you know who's gonna come represent us as a?
They're looking at someone who
Environmental?
specializes in
Environmental.
solar, environmental, and wind.
Okay. Oh, okay. That's the, farmers can be pushed out of all their property illegally or legally, just come and take it. The solar plants, they come and push the
Eminent domain?
farmers and take their land. Is that possible, or they have to actually agree on it and sign in?
They lease the land.
What if the farmer doesn't want it? It's in his family for forever, and the overlay say, well, no, you have to give it up. That's my question, because I see it on the west side of Old 23. It's a bunch of, I live by one farmer. I probably need to speak with him, but he said that he's not selling it, he's not leasing because it's his family forever. What if somebody comes and say, hey, we are taking your land? Is it possible? Is this going to, ordinance here, we are building master plan right now, so we should put really good ordinances by, what we have a visionary sessions and people say this and this. Why don't we put this in the master plan before the vultures comes and grab everything from us? That's my opinion on it. Thank you.
Thank you. Anyone else? Public comment?
I do.
I'm Chris, Tyrone Township. Last meeting, I'll stick with the facts, by the way. I'm not going to do conjecture. I don't believe in that. But the facts is that Carlisle Wortman is not representing the residents. They've already admitted to, openly, that they don't have any legal representation. So maybe I'm a little bit loose upstairs, but for some reason, someone who doesn't do any legal representation is in charge of interpreting a law that's being passed or proposed to be passed in Michigan. I don't get that. My recommendation and observation also says you should have legal help, the specialized person who knows this stuff in every one of these meetings. Every one of them, so that when you have legal questions, you don't go to an organization that has no legal representation. He's even admitted today, in fact, that all of this that you're doing, that he's helping to represent, could just be thrown right out. And all this wasted time and money on that is not good. That's our money that we pay. Another point of reference and observation is at the last meeting, they said that, I apologize. Let me move on to a different, I'll come back to that one. The other thing too is that we have lots of great things in the ordinance. And I stood up here at the last meeting and said, do your plan in spite of the law, in spite of whatever's going to happen in the future. That's still my recommendation. You've heard it here from a number of people. Really important to not do it based on what the fear, and oh, by the way, I remembered, he also, Carlisle Wortman, not he, but you represent them, he also stated as a fact that he wanted the ordinance, the map, to be the most aggressive land use map. He proposed two things, and he said, I want the one that has the biggest one. We have the video on that, by the way. Sorry to say that, but that's a fact. So this is what he's representing, and counsel to you is the most destructive plans, the most aggressive things, the most that fit into what the state wants, not what the people want. This is an important thing. Maybe I'm just missing this point, but this is obvious to me, sitting here and listening to all this discussion. Get the legal representation in here. It's been approved by the board. Heard that from the board meeting. Where are they? Have them here so that they can answer the legal questions because they're the specialists. And then he keeps saying over here, what do you guys want? And you're listening to him on what he wants to put in there. It's a long process, I get that. But we need to do better, and we need to move faster, and we need to get our act together as far as understanding who to get here, who to consult with, and how do we shape this so that it reflects the residents. By the way, if you scroll up, you'll see a wildlife impact paragraph. I don't see any resident paragraph up there, resident impact paragraph, of what the residents are gonna go through. These are just a whole list of things. You're more concerned about wildlife in that ordinance and calling out the fact that we're gonna protect deer, and I don't know a single deer, white-tailed deer that crosses Foley Road that pays taxes, but I do. I pay taxes. I don't know any deer that do. I don't know any wildlife that pays taxes. Why are they getting worried about impact? But the impact to the residents is the most important thing that you guys should be worried about.
Thank you. Yes.
Thank you.
Try to get up 2 times.
Sorry for jumping in there.
Well, no matter what you do, I think this developer has put you guys, the township, between a rock and a hard place. Because you got a house on there with people living in it right now. So that fire danger is higher, and to burn the whole damn thing down is more right now. If you approve this, are you going to approve it so you can maybe never do it? Or are you going to put some time frames on it? So that at least what's already built gets some solutions. Because the other part of this thing is when we signed the deal to let him use our roads, there was supposed to be sprinklers in every house. Well, he conveniently forgot to put it in the deeds on the first 2 houses that were built, so they don't have sprinklers, and that was a requirement of the fire department too. So there's a lot of things like that, and then somebody mentioned Eagle approved his thing because he submitted things. Well, he submitted something that didn't have a floodplain on it. The only darn thing they checked was the floodplain. Not fire, not the T, not this. And there's a second drawing that they claim never existed that had the Y on it. It has the same damn date and number. So all they had to do was switch the thing in and send it, and they put the floodplain on it. I mean, there's a bunch of stuff underneath here that I know the Township Planning Commission has been made aware of it through a number of emails to you. But that's just a few other things. But here's a customer that got sold a lot, and they were never told by either the township or anybody else that they weren't going to get a building permit. Wow. Because it didn't meet the T or the Y didn't meet things. So all these things have happened. So what are you going to do about it? What are you going to do to make sure he gets this done, no matter what it is? Whether you approve it or not, it doesn't matter. It's still got to get done. The T has to be put in, or something has to be put in. And what he's asking you to put in is not as good as what the T is, at least according to the fire department and according to our ordinance. So here we go, What are you going to do? Are you going to get sued by somebody? The township, I mean? Maybe they can't sue him, but he didn't disclose it, like I said, when the closing, because the closing was in August, and this was all known well before then. Because I think it was August 9th, because I got a letter from these people that says, do they owe us any money? Because anytime a lot's sold in there, our township is, my subdivision is owed money for the use of the roads. Because we maintain them every year on our own dime. So I'd like to know who's going to check on this, how they're going to check on it, and why there wasn't checked on while it was being built the first thing. Any big project like this, or even the one you're talking about here, if we don't have somebody in this township checking on these building permits and these things, what the hell? What good are they? They can just do what they want, and if no one lets him know that something's wrong, it's going to get done. Thank you.
Thanks. Any other public comment? Not seeing any? Go to miscellaneous business. And the next workshop is typically on Wednesday. I don't know we've confirmed.
I know
We
that
have items
we've
ready,
not-
but-
we won't have very many people available from what I've heard so far due to Thanksgiving and hunting season. I don't know if, Mateo, do you think that there's any time for turnaround on revised solar stuff?
Let me speak with the principals tomorrow, and I can
So,
be in touch.
so we can send a tentative, assuming that we may be able to get additional solar information, and if not, if we won't have that information, if we don't have enough planning commissioners, we may need to cancel.
Yeah.
Wait till you get a lawyer.
Another item was we talked about it some, Mateo, you talked about the wind item for, in the same vein, right, is, we don't have an ordinance right now specific to that. The utility scale solar, we have one that's in place, it's been in place for quite some time, which is why we were doing this, but the wind part of it, is that something, I believe it is something we should be considering alongside of it. It's probably gonna, especially if we're retaining legal help, right? I think
We'll probably want to
Ross
tie that in.
is should be tied into it.
Right now, our moratorium is specific to solar.
Yeah.
But I believe that, yeah, that's definitely a good idea to tie that into discussion.
Can you get a moratorium for wind?
Possibly.
Yeah.
We need to talk to the board about it.
Okay, so that needs to be on the next board agenda.
As soon as they can get it on. I unfortunately don't have power over that.
I'll submit an application.
I think there was some miscommunication there. As far as application, it's, you apply for planning commission review with an application as something in the ordinance which you can apply for. An agenda request, I guess, is something totally separate, which is.
Yeah, he told me it was an application.
Yeah.
Cunningham
I
said
think
it
that was some
wasn't.
miscommunication
Right,
there.
so I will send an email to,
Perfect.
if the commission's not gonna ask it, maybe the commission should ask the board. Can you guys ask the board to put that on the next meeting?
I don't know how we did the utility scale. Was it requested?
That was, I think the board took initiative on that. At the same time, they directed us to begin review.
Yeah, when we started the county review.
So it does start at the board.
Kurt's the liaison. Can you guys not ask the board to put a wind ordinance agenda item on for the next board meeting?
Mike would be the one that has to make that decision. I don't decide what goes on.
No, I know you don't decide. Can you not request on behalf of the people, we would like to see on the agenda the subject of wind ordinance and a possible moratorium to get that ordinance written?
We can certainly ask that question.
Awesome. Thank you, because it won't,
I'll
it
call
doesn't
them tomorrow.
tell. Thank you.
Yeah, with the legal request, I think it should be part of it, Ross, that way we're getting input how these dovetail with that. All right. Any other items, guys? Alrighty.
No miscellaneous, guys? Don't want to bring that
That's what
up?
we're talking about right now.
Okay, good.
Yeah, the only other question I had, right, and it's related to a lot of the public comments regarding a resolution, Mateo, is if any of the townships you represent have participated in that, or if you've been involved with any of that.
The townships that I've worked with have not.
That's right.
So as far as the function of the planning commission, it's not that the planning commission can't have any say in it. It's the fact that the planning commission cannot adopt a resolution. The township board is the only body that has the authority to adopt a resolution.
I beg to differ. Adams Township has done it.
Do they have specific,
Yep, they signed it, and it was submitted
adopted
to
by the planning commission,
Deerfield,
not the township board?
the planning commission, Deerfield Townfield Planning Commission did, and also, hang on, I think there was a third one in here. Planning Commission did, yes they did. They've got videos on it and everything.
Bylaws, but not an actual resolution.
Yes, they did a resolution. They signed it,
What's that? These are good questions.
My suggestion is that on these big projects, particularly like these farms and things like that, that there may be, maybe an on-site inspection on a regular basis while it's being built, and an annual inspection for safety. Has to be put into this ordinance.
Absolutely,
Thank you. So that it's built according to spec and not some cheater.
That's the only two I see on this list, but this one's the 82 townships and 2 planning commissions and 32 counties.
So, yeah, so that's something that we can consider.
Yeah, Deerfield Township is right here.
Which one?
Deerfield Township.
Yeah.
It's in our wheelhouse. I feel like it is. It's up to us.
Yeah, resolution should be done before, not.
Sorry, I meant resolution. Did I say ordinance a couple times? Because I meant,
No, we know
Okay,
what you meant.
okay,
It's
yeah.
clear in the packet you gave us. Clear. Thank you. So, any other items, guys?
No.
Okay, I'll move we adjourn.
what's your opinion on it? Nobody wants to talk about it?
We just did. We said we feel it should be handled by the board.
It's a board issue.
And your
exactly
board
what we
has
said.
said his feelings are more important than what the township residents want.
I understand what you're
Stand
saying
up.
as one person. That's not the
board is
whole
not
entire
making-
township board. So.
Okay, so,
Yep. Move we adjourn. Support. We need that.
Thank you guys for everything you
Thank you.
do.
thank
Do
you.
the right thing for us, please.
Sorry, who moved in?
So you can drive it this
Or
winter.
I move. Steve.
So you can drive it this winter.
Yeah, there is.
Yeah.